Hello friends, welcome to UGC E-Pathshala. I am Suman Dash Vidya-mitra from National Law University, Odisha, and I am an assistant professor of law here. Today, we will be discussing the very interesting topic of culpable homicide amounting to murder. As we begin, let me introduce the topic to you. Section 299 of the Indian Penal Code deals with culpable homicide, whereas Section 300 deals with culpable homicide amounting to murder. The term homicide refers to the act of killing of a human being by another human being. Homicide may be lawful under certain exceptional circumstances, but in the absence of those circumstances, it is unlawful. Under the Indian Penal Code, unlawful homicide has been covered under sections 302, 304, 304A, 305 and 306, while section 304 deals with culpable homicide not amounting to murder. Section 304A deals with causing death by negligence. Sections 305 and 6 deal with suicide, and sections 302 deals with culpable homicide amounting to murder. Before we go deep into the topic, we should first discuss the difference between culpable homicide and culpable homicide amounting to murder. In other words, culpable homicide that amounts to murder and culpable homicide that does not amount to murder. Murder is a very specific form of culpable homicide. In other words, every murder is at first a culpable homicide. It will not be incorrect to state that murder is a special form of culpable homicide. However, every culpable homicide is not murder. That is also the reason why culpable homicide is said to be the genus of which murder is only a species. If I were to illustrate this, let us consider culpable homicide not amounting to murder as a larger circle, and you could consider culpable homicide amounting to murder as a smaller circle inside the larger one. So, this is how we could illustrate that culpable homicide amounting to murder is just a species, whereas culpable homicide not amounting to murder is the genus. Clause 1 of section 299 overlaps with clause 1 of section 300. Further, there are several exceptions laid down in section 300 which lay down circumstances under which culpable homicide will not amount to murder. So, the manner in which we can interpret the overlapping provisions under sections 299 and 300 is by approaching all cases falling under clause 1 of section 299 and 300 as murder until and unless an exception to section 300 applies. In the event of applicability of an exception, the act may be established as culpable homicide not amounting to murder. The difference between culpable homicide and murder is only a difference in terms of degrees of intention and knowledge, that is, the mens rea that constitute the crime of culpable homicide amounting to murder or murder per se. When the degree of intention or knowledge is less, it falls under culpable homicide not amounting to murder. Likewise, when the degree of intention or knowledge is very high, a case of murder is made out. It is to be noted that when the level of knowledge on the part of the accused is so high that it borders on certainty, or when the effect of causing death of the victim is so likely that it could qualify as extremely predictable, the act will be sufficient to qualify as murder and not just culpable homicide not amounting to murder. As we go deep into the concept and try to explore the various other components of the offence here, it would be necessary for us to explore the elements of the offence of murder under section 302 of the Indian Penal Code. Section 302 lays down that every culpable homicide will amount to the offence of murder under the following circumstances. The act causing death is committed with the intention of causing death. Death results by the doing of an act with the intention of causing such bodily injury as the offender knows to be likely to cause the death of the person to whom the harm is caused. Act is done with the intention of causing bodily injury to a person, and the bodily injury intended to be inflicted is sufficient, we should note the word used here, sufficient in the ordinary course of nature to cause death. Commission of an act which is imminently so dangerous that in all probability it must lead to the causing of death or causing of such bodily injury which has the likelihood to cause death. Such act must have been committed without any excuse for incurring the risk of causing death or injury as mentioned above. So let us discuss the factors one by one here. Understanding the concept is important at this juncture. Doing of an act which causes death with the intention of causing death. Clause 1 of section 300 of the Indian Penal Code prescribes that for the application of this part of the section, the subjective and objective elements will be as follows. Firstly, the actus reus, which is the objective element required for this crime, is the act that has the effect of causing the death of the victim. Friends, it is important at this juncture for us to understand why the actus reus would be the objective element. An actus reus is nothing but the physical act which is required for the commission of a crime. In the case of murder, it must be an act which has the effect of causing the death of the victim. Secondly, the mens rea, which is the subjective element required for this offence, is the presence of an intention to cause death. As explained in section 32 of the Indian Penal Code, the term act includes and covers both illegal commissions and omissions. While a commission connotes some form of positive conduct, an omission refers to negative conduct in the form of intentional non-doing of an act. But any and every illegal commission or omission in itself is not sufficient to qualify as murder until and unless the required mens rea is present. In essence, therefore, an illegal act which is supplemented by an intention to cause death will qualify as murder. Some examples of acts that can qualify as murder are as follows. Here we should note the details that go into the making of these examples. Illegal omission of parents to provide food to their child despite the fact that they had been warned that the child may die without food and the child dying as a consequence of lack of food. The second example would be stabbing a person in a vital part of the body with the intention of causing death of such person. Let us now see what doing of an act causing death with the intention of causing such bodily injury refers to. This is the second factor which is necessary to understand and analyze for the purpose of finding out what murder is or whether or not a certain course of events would qualify as murder. So, doing of an act causing death with the intention of causing such bodily injury as is likely to cause death. Under clause 2, the mens rea of the offender has two aspects. Firstly, the offender must have the intention of causing bodily injury. We must mark the term here. The term used is bodily injury. And secondly, he must have the subjective knowledge that the bodily injury is likely to cause death. So friends, we have two important factors here. First, that there should be a bodily injury, and such bodily injury must have been inflicted with the likelihood of causing death. This clause brings forth a very subjective factor, which is a combination of a certain form of intention along with likelihood. The prosecution must prove beyond reasonable doubt in a court of law that both the factors were present simultaneously to establish a complete case of murder. To explain the applicability of this clause, a simple illustration may be given. Let us pay attention to the details of this example. For example, X is aware that Y suffers from a very serious ailment in the abdomen, and kicking him in the abdomen may not be sufficient to cause death in the ordinary course of nature, but may cause serious bodily injury that may probably cause his death. Mark my words here. The words used are may probably cause his death. So the probability and not the certainty of the death is important here. Thus, due to the presence of the intention of causing serious bodily injury and the subjective knowledge that such bodily injury is likely to cause death, X will be guilty of culpable homicide amounting to murder. So we should notice the vital differences between the first and the second parameter in these cases. Let us try to understand this further with the help of some case laws. In the case of B.N. Shrikantaya versus Mysore State, there were 24 injuries on the body of the deceased, and out of them 21 injuries were incised. Most of the injuries were on the vital parts of the body and were found on the head, neck, shoulders and forearms. The Supreme Court held that the intention to cause bodily injuries was established, and therefore the case could be brought under clause 2 of section 300 of the Indian Penal Code. Now, since we have discussed the first two parameters, it's time for us to also take a look at the third parameter, which is intention to cause bodily injury to a person and such injury being sufficient in the ordinary course of nature to cause death. This is dealt with in clause 3 of the section. Clause 3 says that infliction of such injury must be there which is sufficient in the ordinary course of nature to cause death with the intention of causing such bodily injury. For the application of this clause, the following factors must be established beyond reasonable doubt. Firstly, that there was intention to inflict bodily injury, and secondly, that such bodily injury was sufficient to cause death in the ordinary course of nature. It is important to note that under this clause, if several injuries have been inflicted on the victim, it is not necessary to establish that each injury was sufficient to cause death. It is sufficient to establish that all the injuries taken together were sufficient to cause death, or that there was a single fatal injury that was sufficient to cause death. Further, it is to be noted that it is not a defense in such cases to show that a special skilled person could have escaped the injuries, or that a person with special endurance abilities could have survived the attack. If the prosecution is able to establish it in a court of law that the injury would have been sufficient for causing the death of an ordinary person, it will be enough to make a case of murder under this clause. Under this clause, emphasis is placed on the nature of injuries and intention is attached to the infliction of such bodily injuries. Unless such injuries were inflicted while exercising the right of private defense in serious circumstances, or the accused is able to show that any other general exception should reasonably apply, the presence of the dual factors mentioned under this clause will be sufficient to establish the case of murder. Now, let us take a look at the last important criterion laid down in this section, that is, doing an act with the knowledge that it is imminently dangerous and must cause death in all probability. Clause 4 of section 300 states that when the act done by the accused is imminently dangerous and such that it must cause death in all probability, the accused shall be guilty of murder. Examples of such acts are as follows. First, striking a man with a knife on the throat. Secondly, furious driving in the middle of a crowded market. Thirdly, shooting at a target in a crowded place. Fourthly, poisoning a source of drinking water. Now, if you take a look at all the above examples, the nature of the act is such that it is potentially hazardous and has an extreme probability of causing death. In all the above examples, the accused indulges in actions which are inherently so dangerous that death is a highly probable consequence and is most likely to be the natural consequence. Let us take a look at few cases to further understand and illustrate this important point. In the case of State of Madhya Pradesh versus Ram Prasad, the Supreme Court held that the clause can also be applied to cases where the act done by the accused displays callousness towards the end result and has the likelihood of resulting in death. In this case, the accused had poured kerosene on his wife and set her on fire. The Supreme Court remarked that when he did such an act, he should have known that it would have led to the death of the victim. The should have known subjective element which is applied here is a very pertinent one, because in such cases the gravity of the act itself indicates the mens rea of the accused. In Thangaya versus State of Tamil Nadu, the Supreme Court ruled that clause 4 of section 300 would apply in cases where the knowledge of the offender regarding probability of death of a victim is to such an extent that it borders on practical certainty. So, we have taken a look at the various clauses, various factors which can attribute and can qualify as culpable homicide amounting to murder. However, clauses 2 and 3 of section 300 are characterized by very significant differences. So, let us now try to analyze the difference between clauses 2 and 3 of section 300. There is a significant difference between the levels of mens rea captured in clauses 2 and 3 of section 300. The case of Virsa Singh versus State of Punjab is a landmark decision of the Supreme Court and is historic because it prescribes and lays down very succinctly the difference between these two clauses. In this case, the Supreme Court prescribes a four-fold test that must be applied by the prosecution to apply section 303 to a given case. The four-fold test is as follows. Please pay attention to the details of the test and let us try to analyze what the test tries to tell us. First important parameter is that the prosecution must objectively establish. The term to be emphasized here is objective establishment. So, the prosecution must objectively establish that a bodily injury is present. Secondly, the nature of the injury must be proved. This injury is completely objective in nature. Thirdly, it has to be proved that there was an intention to inflict that particular bodily injury, meaning thereby that the infliction of the injury was neither accidental nor unintentional. It also has to be shown that the accused did not intend any other kind of injury. Finally, it has to be proved that the injury, which has the elements mentioned above, must be sufficient in the ordinary course of nature to cause death. This part of the inquiry is also purely objective and inferential and has nothing to do with the intention of the offender. So far as section 300 clause 2 is concerned, there are two levels of intention that need to be established by the prosecution. Firstly, that there was an intention to cause bodily injury, and secondly, the accused must have the subjective knowledge that such bodily injury is likely to cause death. But under section 300 clause 3, it is sufficient to show that there was intention to cause the bodily injury that was actually caused. There is no further subjective inquiry that needs to be carried out. What follows next is just an objective inquiry to find out whether the injury caused was sufficient in the ordinary course of nature to cause death. At this juncture, one needs to contrast this provision with section 300 clause 2, which prescribes a second step in the subjective inquiry by stating that apart from having the intention to inflict the bodily injury, the accused must also have a subjective knowledge of likelihood of the effect of death from the injury. Now, in the case of Virsa Singh, the Supreme Court has observed that there is no requirement on the part of the prosecution to show that the accused has subjective knowledge of the sufficiency of the bodily injury to cause the death of the victim. It went on to declare that the two parts referring to intention in clause 3 are entirely disjunctive, and the first part of the intention to inflict bodily injury has no bearing on the second part of the sufficiency of causing death. On the other hand, in clause 2, the two levels of intention must go hand in hand. Now, as we try to understand this topic further, let us also try to understand the concept of attempt to commit murder. At what stage can we say that a certain thing has amounted to an attempt to commit murder? Like other offences, the Indian Penal Code penalizes attempted murder under section 307. For attracting the provisions of this section, the prosecution must establish that the following two elements are established. Firstly, the intention or knowledge to commit murder is present. Secondly, the actual act of trying to commit the offence of murder has been there. In order to convict the accused under this section, it is necessary to establish that had the accused succeeded in his attempt and death of the victim would have been the result, the accused would have been guilty of the commission of murder and punished under section 302 of the code. So, what are the exceptions then under section 300? Without discussing this, a discussion on murder is always incomplete. Under section 300, the exceptions which are provided are as follows. Firstly, grave and sudden provocation. Emphasis here is on provocation which is not only grave but also sudden. The second element is private defense. Then we have acts of public servants, sudden fight, and finally consent. In the presence of any one or all of the above factors, the offence committed by the accused will not qualify as murder. As we analyze the cases here and as we go through the topic, it is important for us to understand the case studies in this area. It is worthwhile to discuss some important case studies in relation to the offence of murder. and I will begin, friends, by first discussing with you the case of B.D. Kunte versus Union of India. In this case, a young soldier in the army was sexually assaulted by his superior officer in the daytime. In the evening, while discharging his regular duties, when the superior officer approached him without disclosing his identity, which under the rules he was bound to do, the soldier shot him dead. The soldier was held guilty of committing the offence of murder on the ground that sufficient time had elapsed after the happening of the sexual assault, and this period could have been enough for the soldier to regain his senses. According to the Supreme Court, the cooling off period, which is the time period between the provocation or the happening of an incident which has the potential of grave and sudden provocation, and the actual commission of the culpable act. This cooling off period negates the impact of the gravity and suddenness of the provocation, and in such cases the exception of grave and sudden provocation cannot be applied. It is important for us to reflect and try and find out whether this case could have attracted the grave and sudden provocation clause. In Ravi Kumar's case, which is another significant case in this area, the accused has set his wife on fire after a quarrel with her on the issue of visiting his ailing father. After this, he had bribed both his children with trivial amounts of money to stay silent about the incident and took them off to another town, but not before locking up his burnt wife. Upon his return, he acted surprised about the incident in the presence of his neighbors. Although the entire incident indicates a clear intention on the part of Ravi Kumar to kill his wife, the Supreme Court held that it was not a case of murder, as exception 4 to section 300 would apply in this case. What is important in a case to gauge and assess intention in cases relating to murder is also the activities of the accused after committing the crime. So it is important for us to understand what Ravi Kumar did here. After committing the crime, when he bribes his children to remain shut about the incident, locks his burnt wife inside the room and leaves off, and then acts surprised in the presence of his neighbors, would it not indicate towards an intention which is very clear and specific, and hence should the situation not amount to murder? This is a question which as learners you must reflect on. However, it is significant to note that under exception 4, a mere quarrel is not sufficient to negate the elements of murder. It is necessary that the sudden quarrel must have led also to a sudden fight, which is followed by the act causing the death of the victim. In this case, not a single fact indicating a sudden fight was established. It was only established that Ravi had a quarrel with his wife. There was also no deliberation on whether this could have been a sufficient ground for grave and sudden provocation. In the absence of any of these exceptions, ideally, it should have been a clear case of murder. Now, as we have gone through all the components that are necessary for an act to qualify as murder, let us finally conclude the topic. For culpable homicide to amount to murder, the prosecution has to establish beyond reasonable doubt that the accused had a very specific mens rea, as discussed in section 300, along with the required actus reus. Murder is a serious crime, and therefore the requirements of mens rea and actus reus are very clearly defined. So, as we proceed further, let me summarize the entire lecture for you. The most important thing that you need to remember about culpable homicide is obviously the meaning of the term. The term homicide refers to the killing of a human being by another human being. homicide is lawful only under certain exceptional circumstances. So for example, it is lawful when it happens under a circumstance where it is necessary for the police, for instance, to capture a convict who is escaping the clutches of law, or it is lawful, for instance, when the death penalty is being inflicted. But in the absence of those circumstances, it is unlawful. Every murder is at first a culpable homicide, whereas every culpable homicide is not necessarily murder. I would like you to think back and reflect on how we tried to suggest that culpable homicide not amounting to murder is the genus, whereas culpable homicide amounting to murder is the species. When the degree of intention or knowledge is less, it falls under culpable homicide, and if both of these are so high that they border on certainty, then the act amounts to murder. To qualify as murder, every culpable homicide should pass the test of section 300 of the Indian Penal Code. That is, act causing death is committed with the intention of causing death. Death results by the doing of an act with the intention of causing such bodily injury as the offender knows to be likely to cause the death of the person to whom the harm is caused. Act is done with the intention of causing bodily injury to a person, and the bodily injury intended to be inflicted is sufficient in the ordinary course of nature to cause death. Commission of an act which is imminently so dangerous that in all probability it must lead to the causing of death or causing of such bodily injury which has the likelihood to cause death. Such act must have been committed without any excuse for incurring the risk of causing death or injury as mentioned above. In Virsa Singh versus State of Punjab, the difference between levels of mens rea under sections 302 and 303 of the Indian Penal Code has been discussed. The exceptions of murder are as follows: grave and sudden provocation, private defense, acts of public servants, sudden fight and consent. In B.D. Kunte versus Union of India, the application of grave and sudden provocation as a defense has been elaborately discussed. Now, on this note, I would like to conclude the topic for you. Hope you learnt well and hope you learn more. Thank you.